The next case to come before the court is State of Ohio versus Christopher Hayes. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of children or minors or victims during your argument. You can refer to those folks by general terms or by initials. The judges have read your briefs and we're ready to proceed when you are. And I would just ask, Mr. Sheldon, would you like to reserve time for rebuttal?
Yes, Your Honor, I'll respectfully request 3 minutes for rebuttal.
Very well, then you may begin when you are ready.
Thank you, Your Honor.
Sure.
Mr. Huber, good morning, judges, Judge Sutton, Judge Carr, Judge Flagg-Lanzinger. My name is David Sheldon. I represent the appellant, Mr. Christopher Hayes. In this particular matter, you've read the brief, so I'm not going to be lengthy in my argument. I'm trying to keep this short and sweet. The main gist, I think, of my argument focuses on the assignment of error number 1, that the trial court erred in finding that there was reasonable articulable suspicion to detain Mr. Hayes to perform standardized field sobriety tests. I went through my brief, and I think I pointed out on page, my merit brief, under assignment of error number 1, pages 10, 11, and 12 of that brief, where I cited to the judge's findings of fact and then set forth why his findings in citing state versus evidence with the various, I think it's 11 or 13 factors for the courts to consider for reasonable articulable suspicion in an OVI case, why those findings of fact were not supported by competent, credible evidence. So I have those arguments in there. I asked the court to read through those. I think they're spot on. But with respect to this case, significant, I think, in these cases is when you look at reasonable articulable suspicion and what's required, and you go through the standard things of an admission to alcohol consumption, bloodshot, glassy eyes, slurred, mumble speech. Those are typical characteristics of which I would say all 3 of those are missing here. Now, Officer Miracle testified, well, at the suppression hearing, he testified his eyes were bloodshot and glassy. Well, he never indicated that in his narrative report, which I think is significant, because officers are trained to write down all the special significant facts and details that give rise to reasonable articulable suspicion.
Attorney Sheldon, did he say in his report something about red eyes, or was it?
I think it was red or glassy eyes, Your Honor, yes. So, and I'm trying not to make a big distinction here, but you know, the NHTSA manual talks about bloodshot eyes as an indicator of potential impairment of alcohol or drugs, not glassy or red eyes. So that was one factor I dispute in terms of the facts that the officer cites. But on page 5 of my merit brief, one of the other things I think the court drew from the record was, well, you know, this drowsiness and dizziness. Well, there was no indication that the officer testified that the medication that he found in his car causes dizziness. He said the label said may cause drowsiness. But significant with respect to that testimony and leading to the court's conclusion that this somehow explains Mr. Hayes' behavior at the scene as somewhat being lethargic, quote, lethargic, or sluggish, close quote. The officer testified in his experience in drug and being a READI officer, advanced roadside impairment and drug enforcement, that typically it's typical to have constricted or dilated pupils with people under the influence of drugs. He specifically testified Mr. Hayes did not have constricted or dilated pupils. So I think the court goes out on a tangent to try and come up with an explanation and cite some other cases that's not in the record. Officer Miracle never testified my client was drowsy. I think the court pointed out the video and said, well, you know, he appears drowsy in the video. Well, and that must be the explanation from the medication. The officer, again, never said my client appeared drowsy. He indicated he never counted the pills in my client's pill vial that would indicate how many pills he took, but we do have concrete evidence from my client that he took the muscle relaxers and Motrin at 9 or noon that day. This call comes in at 9:11 p.m. We're talking 9 hours later. Also significant, the officer did not smell or detect the odor of alcoholic beverage. He specifically said that, and I point that on page 5, where I put, quote, the officer came very close to Mr. Hayes, could not smell anything as far as alcohol goes, close quote. That's in the transcript, pages 34 and 35. And the court did not find that. Trial court did not find that my client had consumed alcohol. So we're going out and we're formulating a conclusion here based on these facts. Well then, Mr. Hayes must have been somehow under the influence of drugs. And there was no testimony of that. There was no testimony that my client was under the influence of drugs, nor was there evidence to support that. In this particular case, as I said, he did not have constricted or dilated pupils. There's no classic indicia of impairment, no slurred speech, no mumbled speech, no omission of alcohol consumption. I might dispute the bloodshot eyes. And you just don't have those factors that lead to the conclusion, to reasonable articulable suspicion that he is under the influence of alcohol or drugs. The court pointed out, and I think the court focused a lot upon, well, he appeared sluggish or languid in his movements. And I indicate, and the officer testified, he's familiar with deer in the area. They commonly cross the roads. It's not uncommon for deer to run across roads in Hinckley.
Counsel, was there a change in the story of what had happened, the accident itself, how that came to pass? Did that kind of evolve, as I recall?
Yes, and I pointed out in my merit brief, Your Honor, and I think it's not beyond common knowledge that someone that goes off the road trying to avoid a deer hits a mailbox, hits a culvert, hits a flower box, hits a guardrail, and then hits a tractor parked in the car with full airbags deploying, is not going to have some, as the officer testified, he was shaken, effects from hitting those objects and obstacles, and could explain why he's got an evolving account. He's trying to recall the events after he hits all these objects. He's stunned, he's shaken. Yeah, I'm not sure, all of a sudden it was a mailbox or it was a flower box flying out. I think I did swerve to hit something. It was a deer. Yeah, that could be explained exactly by, as the officer testified, it's common for people in these type of situations that have car accidents, to have concussions, to not recall things clearly, etc. But the court's only focused on and tried to conclude from the evidence in this case, which I again argue does not support that conclusion, that he was under the effects of the drugs he had taken at noon that day, 9 hours earlier. So I think the court went on a major stretch, and as I indicated, the factors it cited in their statement versus evidence simply, and I went through all of them, the court was incorrect on almost all the factors he cited. One was about physical coordination, factor number 10, which he tries to say under factor number 10, the evidence decision, well, he had this evolving account, et cetera, does not explain anything about lack of physical coordination. There was no testimony my client fumbled for his keys, had any problems with dropping anything there at the car when the officer was speaking to him. So that, again, is not supported by competent, credible evidence in the transcript the court cites to. And I indicated the court went outside the record to find facts from another case and conclusions drawn from another case to support his conclusion, well, he must have been under the influence of drugs here, which is not proper because it's not in the record. He was not citing to the record in the officer's testimony to support those conclusions. He went outside the record, went to other cases to come up with a conclusion that fit his scenario of what the facts here show. So I'm not going to go any further. I would ask the court to also consider the arguments I set forth in the probable cause issue. As I said, the officer testified when he went up to his supervisor and said, he's got a bad back, go ahead, and the supervisor says, go ahead and put him through the field sobriety test. He says, even though he's got a bad back, he goes, yeah, just document it, put it in there that he's got a bad back. So I would ask the court to take that all into consideration in these assignments in error, and I respectfully request that the court reverse the decision of the trial court for the reasons set forth in my merit brief. Thank you.
Thank you, Attorney Sheldon. You'll have your full 3 minutes for rebuttal.
Thank you. May it please the court, my name is Greg Huber. I represent the state in this case. I would respectfully disagree with Attorney Sheldon. I thought the trial court, Judge Warner, accurately assessed the evidence that was presented at the motion to suppress. This court has before it, as a part of the record, Defendant's Exhibit A1, which is the body camera footage involving the interaction between Officer Miracle and Defendant Hayes. I think if the court takes the time to review that body camera footage, you'll find the trial court's assessment of this case is dead on. This is a case where the officer was called out at 9 o'clock in the evening on Madigan Road, found the defendant in a single car accident where the accident itself involved him going off the road for no reason. There was no other vehicle involved. Initially, as Judge Sutton points out from the record, the defendant's explanation of what happened absolutely changes within the span of about 5 minutes. He's initially asked what happened because this accident suggests erratic driving. The defendant himself plainly caused the accident. And it is a situation where an officer, I think, reasonably is going to ask, well, what happened here? Initially, this defendant says he doesn't know. Then he goes to, I don't remember. Then he says to the officer, I don't think I fell asleep. And then he says, I was just driving and swerved. And then he says, later, I thought it was a deer. And then at the very end, his last explanation, he's sure it was a deer. Now, Attorney Sheldon suggested in his brief that this may be from the impact or a concussion or the accident itself as he's trying to recollect. But for a police officer, reasonably, and I think this will bear out if you look at the body camera footage, number one, this defendant seems to be off. Number two, his explanation suggests possibly fabrication. And if I was a police officer, that's what I would think, and that's what I thought as a prosecutor when I reviewed this before I tried the motion to suppress. So we have erratic driving, we have an explanation that is shifting, it seems to suggest possible concealment of what actually happened. The officer did notice bloodshot, glassy eyes. The officer then secured a statement from the defendant that he takes medication. The medication bottle is right there in the car. The officer verifies that. And this medication is indicating that if combined with alcohol will cause drowsiness. In this situation, the officer also testified at page 16 of the transcript that he smelled an odor of alcohol, but he wasn't sure. This officer only had about a minute to talk to this gentleman, and you'll see he was then taken to the EMTs who wanted to check him out for the obvious reasons. And notably, the EMTs are not allowed to render treatment because the defendant doesn't want them to. And then the defendant doesn't want and refuses to go to the hospital. Now again, from a reasonable police officer's point of view, there may be another explanation, but an officer would suspect the possibility of concealment as to what's really going on with this gentleman, and suspect that this gentleman doesn't want anybody to know what his condition is. The factors that the courts look for in determining reasonable and articulable suspicion, I think, are present in this case. The trial court in its entry found that the officer didn't detect an odor of alcohol, and the judge wrote that, but I respectfully disagree. If you look at page 16, the officer says, I detected an odor of alcohol, but I didn't spend enough time with him to be able to tell for sure. The officer then says, I knew something was wrong with him. I didn't know whether it was alcohol or not. I suspected it may be medication, but I just wasn't sure. Later, he testifies that he did have time with the defendant, and he did smell the odor of alcohol. But we're kind of cut off to going into later because I'm presenting evidence concerning reasonable articulable suspicion, probable cause, and then we get into the field sobriety tests. So what the officer testified to is confirmed later, and he testified to that in his statement, in his testimony, but I think taking the issue of odor alcohol completely out of this case is not really correct to what the evidence offers.
Counsel, on the issue of not accepting medical treatment and not being willing to get help in that way, that happened prior to, in the order of things, how did that happen?
That happened before he administered field sobriety tests. The other issue that came up was his sergeant had called this gentleman's wife. The wife advised that he takes medication and takes his meds, and that he was at a golf outing. This gentleman had golf bags and golf shoes in his car. Again, a police officer might reasonably wonder whether a person had a few beers at a golf outing combined with the medication, but that's what field sobriety tests are supposed to tell you. All this information was given to Officer Miracle prior to his administering field sobriety tests. If you look at the totality of all of this information, and you look at it through the eyes of a reasonably seasoned police officer, I would respectfully argue that I would think the courts would want this officer to check this gentleman out, see if he was impaired or not. And I would think the policy, as a general matter, would encourage that. With this information, I just have a tough time thinking that an officer should just let him go. I wouldn't. I've been a prosecuting attorney for a while, and I think the officer should have administered field sobrieties given the information that this gentleman had. And field sobriety tests then basically confirmed further what the officer's suspicions were. The officer then asked this gentleman to take a PBT, and he refuses. And then, of course, he refuses later to take a breath test. This case stacks up, I think, as a reasonable actions on the part of the officer in trying to handle this investigation, which frankly, when you see the body camera, is a little bit chaotic, trying to keep it in order. I would encourage the court to look at the evidence both in the trial transcript and in the body camera. I respectfully submit that the trial court did an excellent job of summarizing exactly what the body camera and the testimony of the officer established. We contend that there was reasonable suspicion that would justify administering field sobriety tests. This gentleman didn't do well on field sobriety tests, and there was probable cause to take him in to ask him to take a breath test. And for that reason, we would respectfully ask the court to uphold the trial court.
Counsel, I just have one question before you are
Yes.
seated. The appellant is alleging that the trial court also made findings or reached conclusions that were not supported by the record, such as, he cites in the brief, the court found that his manner was reasonably explainable by the effects of the medication defendant admitted having taken. And I guess the question becomes, how does the court know how medication will affect this individual? None of that was in the record or anything, right?
Well, this defendant didn't come across as normal when his interactions occur. He's admitting to taking medication. The medication suggests exactly what this gentleman presents when you interact with him. And here again, I think if you look at the body camera, the trial court's finding is justified. I thought the same thing when I looked at it. This fellow's not right. He shouldn't have been driving.
Of course, that was also after airbag had been deployed and hit him.
Well, again, a police officer is supposed to parse this out. That's one explanation, but another equal explanation for a police officer who needs to probe a little bit is this gentleman may be impaired. He needs to find out, and I think he did. So I thought the trial court had
a good justification for what he indicated and wrote out in his opinion. I suppose this court will have to look at this body camera, and I suppose if you disagree, you'll tell me. But I thought the judge was spot on. Thank you.
Thank you, counsel. You may proceed on rebuttal. You have your full 3 minutes.
Thank you, Your Honors. Judge Carr, I think you kind of hit the nail on the head in terms of concluding from a lack of evidence in the record that my client must have been under the effects of drugs in this particular case, again, which I don't believe is supported by the record. This officer is not a doctor. He never testified in his opinion that my client was under the effects of drugs. He did say at one point in the record, he came, I think the question was asked by Mr. Huber on direct about the drugs, and he says, well, that may be a contributing factor in this matter. Again, though, the officer, as I pointed out, did not see constricted or dilated pupils. My client did not have the classic condition of impairment. He did not have slurred speech, mumbled speech, did not have, as I argued, I take dispute as Mr. Huber does with the record about alcohol. He denied consuming alcohol, and the court did not make that finding. The court specifically did not find that my client had consumed alcohol. So this is really a drug impairment case. And again, getting back to, as Mr. Huber points out, well, I think he did the right thing in detaining this guy and put him through field sobriety tests. And if this is a drug impairment case, as you know, these field sobriety tests, the triad that he's trained on, NHTSA, National Highway Traffic Safety Administration tests, specifically designed, the 3 battery tests. And you know this from the case law, and you've written the case law in this 9th district, that these tests are designed to determine the likelihood that somebody is going to test .08 or higher, the likelihood that they're going to test over the legal limit in Ohio. That's what these tests are designed for. They're not designed to detect drug impairment. As you know from the case law, what a drug impairment officer is, a DRE officer is, they determine after the fact. They come in after the person's been arrested on an OVI traffic stop. They come in and do an assessment of the individual post-arrest at the station, whether or not in their professional opinion, as a drug enforcement officer, this person is showing signs of drug impairment. That's not here in this case. We don't have a drug impairment officer coming in to testify post-arrest what he considers to be signs of or indicia of drug impairment. We don't have that. So in this case, as I explained, this evolving account, I think, is really what the court focused on with my client, and I think that's easily explainable by the events of him going off the road. Mr. Huber says erratic driving. There's no testimony from an independent witness or a motorist saying, you know, call 800 DUI, that guy's all over the road. All we know from the record is he had an evolving account, and he swerved to avoid a deer, is what he came to at the end. And I think that's reasonably explainable.
The accident itself is a factor.
Yes, Your Honor, I would agree with you
And it
totally.
can't be the only factor, but if there's other factors in conjunction, we're talking about reasonable suspicion, correct?
Yes, and I totally agree, Judge. I mean, failure to control a vehicle, we have to be in reasonable control of our vehicles when we drive down the road. So clearly, if he drives off the road, that could be failure to control, although if he says it's because a deer was in the roadway, you know, we see deer and people, a lot of times people can't avoid hitting them and hit them. I've hit a deer, I think many people have hit deer running out on the road at night, so, but it's not an unreasonable reaction to swerve to avoid hitting a deer and go off the roadway. So for those reasons, I ask the court to reverse the decision of the trial court. Thank you.
Thank you very much. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk, of course, will mail that decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you again.
Thank you.